a moment.
And we are live.
Okay. Oops. Oh, are we live now?
We are.
Okay. It's Friday, April 7th, and we are here, the House Sexual Harassment Prevention Panel, and we are continuing our work looking over the rules of procedure. So, and while you're starting, I'm going to see if I can get Representative McCoy here.
Sure. For the record, Damian Leonard, Office of
Representative
Legislative.
Brannigan is on her way over now.
Okay. Damian Leonard, Office of Legislative Counsel. We're going to resume with Rule 8 in the Rules of Procedure, which I've just pulled up. So this rule requires the panel, if it determines that the allegations in a formal complaint, assuming they were true, would constitute a violation of the policy, it requires the panel to contract with an investigator to investigate the allegations. That investigator would likely be the law firm that's retained by the General Assembly. And then the contract with the investigator would have to outline the scope of the work, including a requirement that the investigator produce a report with a determination in the investigator's opinion as to whether the policy had been violated.
Thank you.
Rule 9 requires the panel to promptly provide a copy of the investigator's report to both parties, and then to review the report and make a preliminary determination as to whether a violation of the policy occurred. And if, based on the report, the panel makes a determination that there was no violation of the policy, the complaint would be closed and remain confidential. And then 2 or more panel members would meet with each party. It could be meeting separately or together, depending on the wishes of the parties, and would summarize the basis for the panel's determination. And then the panel would have to provide a brief letter summarizing its decision without identifying information to both parties, and then would also have to notify the speaker that the complaint was closed, but with no identifying information in the notification. On the other hand, if the panel makes a preliminary determination that a violation of the policy occurs, 2 or more panel members are required to meet with each party. It could be either separate or together as before, and allow the parties to review any documents or evidence that the panel has obtained in addition to the report, and inform the parties of the basis for the panel's determination, and then take further action pursuant to Rule 10, which provides that the panel could do one of the following. It can issue a written warning to the respondent, which would identify the provisions of the policy that the panel finds there's reasonable grounds to believe were violated. And then provide a brief summary of its actions to the complainant, including a reference to the provisions that it found reasonable grounds to believe were violated, but without identifying information. And again, brief notice to the speaker without identifying information. The second option is to enter into a mutually agreed resolution with the parties. The panel is permitted to attempt to negotiate a resolution between the parties. And then if the parties agree, both parties would be provided with a copy of the terms of the resolution, and the chair would promptly inform the speaker of the disposition, but again, no identifying information. And then the final option, and the most extreme option here, is to draft and present charges and set the matter for a hearing. So the panel would draft charges alleging a violation of the policy, provide those charges to both parties, and set a date, time, and location for a hearing. The respondent would be allowed to file an answer to the charges. And then after the date and time were set, the chair would promptly inform the speaker of the incident or conduct at issue, that the panel has drafted charges, but would not identify the complainant or regulated individual yet. And then the parties are allowed to jointly agree to waive the hearing at any point in the process if they decide they're ready to resolve the matter prior to hearing. So that brings us to the issue of conflicts of interest in Rule 11. A panel member who is a party to a complaint is not allowed to participate in any panel proceedings or discussions. And then a panel member who is a witness may be prohibited as the panel deems appropriate. So depending on the nature of the incident and what the panel member witnessed, the panel could determine that that panel member is going to be too biased to be objective in reviewing the case. The panel holds hearings in two instances. One is following drafting of charges. The other is if there's an appeal filed, which is a later rule. And then at the hearings, the chair of the panel would preside. The panel would have legal counsel present and the assistance of either the Office of Legislative Counsel or of outside counsel as appropriate. Would have the administrative assistance of the Office of Legislative Operations to secure a room and take care of the logistics, and can contract with the investigator or another person to prosecute the charges. That person would then present the report to the panel and could present additional evidence and call and question witnesses and present arguments in favor of finding a violation. The panel is not bound by the Vermont Rules of Evidence and may admit any evidence that the panel considers to be reliable, material, and relevant. So this means that evidence wouldn't be excluded, for example, just because it's hearsay, if the panel determined that that evidence was reliable, material, and relevant. The chair would make evidentiary rulings, but could be overruled by a majority of the panel. And the burden of proof is clear and convincing evidence. I'm going to pause here.
Can I?
Yep.
I'm sorry, every time this comes up, I need a refresher on those three
What is it?
levels of
Me too, yes.
clear and convincing, preponderance of evidence, and then beyond a reasonable doubt. And
Yes.
which is
So preponderance of the evidence is anything more than 50%. So if you imagine the scales, it's that point where the scales tip. Clear and convincing evidence means that the evidence has to be certain, unambiguous, and plain to the understanding, and also has to be reasonable and persuasive enough to cause the panel to believe that the conduct actually occurred. Beyond a reasonable doubt means literally you cannot have any reasonable doubts regarding whether the conduct occurred. So clear and convincing, it's worth noting, is a higher standard than you would have in a civil case if you pursued. So if you were trying to prove discrimination in court, it's a preponderance of the evidence standard. Clear and convincing is a higher standard. That has been the standard in the policy for as long as I've been here. But it's worth noting that this is not consistent with the standard that if someone decided they were unhappy with the outcome and they took this case to the Human Rights Commission or to the Superior Court, they would be facing a lower standard of proof to prove that discrimination occurred. So, but that is, I just wanted to call your attention to that. It's a policy decision for the panel. In the past, the panel has kept the clear and convincing standard because of concerns about if it's a close call. making a determination on the preponderance. But again, it's a policy decision and you can change that standard if you wish to. One of the things too is because this is no longer, because we've now separated the rules of procedure out, if the House decides to have a different procedure from the Senate or even from the House discrimination panel, that is permissible. You can decide that the standard of proof should be different.
Do you mind if I?
Sure.
I mean, I would be in favor of at least talking about backing off to preponderance of evidence. I worry that clear and convincing evidence tends to protect the respondent more so than the complainant. I think preponderance of evidence brings to the table an arena that is a little more, at least, willing to believe the complainant. So I think it gives us a different arena to have the conversation in, I guess is how I'll say it.
I agree. We wanted to change that. We have to.
Yeah, and it would be something that we could put in as a proposed change in a draft, and you can continue to consider it. You don't have to decide this
especially
morning.
since Patty's not here, I think.
Right, I mean, the whole panel's not here. And it's, anytime you're talking about an evidentiary standard, it's a significant factor in the decision. So I can certainly put it in the draft and then you can continue to think about it and talk about it. And then make a decision when you've seen it in the draft and had a chance to fully consider.
I definitely want to think about that.
Okay.
So when it's in the draft, we can all see what it looks like and talk about what it really means. I feel like the clear and convincing, that's the one where you need the higher level of.
Yeah, so clear and convincing is what we would call an intermediate standard of proof.
And that's what's there now.
Yeah, so it's not quite the criminal law beyond a reasonable doubt, but it is a higher standard of proof than the standard civil law preponderance of the evidence.
Well, in our role as a committee, we don't need to have that higher standard. But on the other hand, I worry about the accused. I worry about the accuser also, definitely. And I think by nature, I would agree, I would believe that accuser. But the accused has rights too. And maybe he didn't do it. Maybe maybe what he did was misinterpreted. And so I think we need to think about this. And it could be she too. I used a pronoun, but I want to think about it. And I'm only one vote, so.
Well, I think we're all willing, we'd all like to think about it.
Yeah, and, I've got notes on changes. And then what I'm going to do once we're finished going through this draft is put together a draft that's marked up and then present it to you for review so that you can continue to make changes or say, you know what, we don't want that change now that we've looked at it. So nothing here is final.
And I think also, like, given where we are in the session, I mean, my feeling is hopefully we can decide on something before the end of April.
Yeah.
Because things get a little crazy at the beginning of May, and I think that we don't want to, I don't think we want to leave this hanging out there. I think we want to get it nailed down. So we can do that, look at it, and maybe at the next meeting, sort of come to some final decisions.
Yeah, and it's a 2-year biennium too. So the other thing to keep in mind is if there are things that are easy to agree on now and things that are harder to agree on, you can always tackle the low-hanging fruit and continue to consider some of the more challenging issues, if the panel's having difficulty reaching agreement on things.
Okay.
So the last thing I did want to note is that even though the panel could consider, for example, hearsay evidence, the entire decision cannot be based on hearsay evidence. So this is to avoid having a decision based on State House gossip, for example, rather than having some actual facts.
Can I just
Yep.
I just want to make sure I have this straight. So hearsay evidence in this sort of scenario is a witness who might provide testimony stating that the complainant talked to me immediately after the incident. And
Yep.
this is how they conveyed. This is how they appeared. Right. That in normal circumstances could be considered hearsay, but we're listening to it as relevant information to provide credibility to.
Right. So you could listen to that as a relevant information because it was a contemporaneous account of what had happened, and there wasn't, so one of the things we look at in a trial, if you're looking at evidence, and there are exceptions to the hearsay rule, for example, for certain types of declarations or accounts where because it's so present that it's unlikely to have been doctored,
Right.
or affected by, I think we're all familiar with the process where when you remember an event, the memory starts to change over time as you think it through and talk to people. And your story may change a little bit too. And not to say that, not to cast doubt on either party, but something where you're delivering an account 3 months later versus 10 minutes after the event happened will be different accounts. And so this allows you to consider both types of evidence and then to give them their due weight. So you could give more weight to the present recollection versus the later recollection 3 months later that might be slightly different. But this allows you to consider both when it's something like that.
Thank you.
Yep. So Rule 14 gives the parties rights at the hearing. Both parties are allowed to have an individual of their choosing present to provide support and may hire their own counsel at their own expense. Counsel or any individual who's present to provide support shall not be a potential witness. And then the complainant and respondent may testify, and the complainant and respondent or their attorneys may also present evidence, call or question witnesses, and present arguments to the panel. So this allows both parties to influence how the hearing goes. So potentially if the complainant does not think that the panel has pulled all of the salient information regarding the incident, they could ask their own questions or present additional evidence that the panel didn't consider. And of course, the respondent is given an opportunity to defend themselves and to try to present evidence that would exonerate themselves. So, Rule 15 provides that the hearing would be closed to the public unless both parties agree to make it open to the public. It's, I would guess, fairly unlikely that a hearing would be open to the public unless for some reason the incident had already become public knowledge in the State House, in which case the parties might want to have the hearing held publicly so that, there wasn't a case of people trying to say what had happened behind closed doors. Outcome of the hearing. So it requires 4 panel members. for the decision. So if at least 4 panel members find that there is not clear and convincing evidence that a violation of the policy occurred, the panel dismisses the complaint. And then again, meets with the parties to summarize the basis for their determination, provides them with a brief letter summarizing the action with no identifying information, and notifies the speaker that the complaint has been dismissed, but with no identifying information. If at least 4 members of the panel find that there is clear and convincing evidence that a violation of the policy occurred, the panel would recommend corrective action pursuant to the next rule. And then after that action has been recommended, the chair would meet with the speaker, inform the speaker of the nature of the complaint and the identities of the parties, and summarize the basis for the panel's determination and recommended corrective action. And this meeting would only be necessary if the speaker has not otherwise received that information. So this is the pretty much the only instance when the panel will notify the speaker of all the details of the complaint. Otherwise, it's just what was the outcome. So this does require 4 panel members to find that there's clear and convincing evidence, which ensures that a member from each party has voted to agree, so you don't end up with a partisan ruling. And the potential difficulty here is if it's a really close call, a 3-2. It's something we don't address in the policy. And so it may be something you want to consider. What would happen if you have a 3-2 decision? Because then right now it's 4 to dismiss and 4 to find that a violation occurred. But there is the possibility that you could have a 3-2 vote. And there's also a possibility if one member of the panel has had to recuse themselves, that you could have a 2-2 vote or a 3-1 vote. And so do you need to have all 4 members vote in favor or against if one member has recused themselves? So just things to consider. But there are a couple scenarios that this rule doesn't contemplate. The other piece to keep in mind too is that there is the possibility, if you get into one of those scenarios, to vote to suspend your rules. I would strongly advise against voting to suspend your rules to either dismiss or find a violation, because that, particularly if it's a 3-2 split. But if, for example, you have a member who's recused themselves, you could suspend the rules to say that only 3 members present need to find the violation occurred.
Can we issue no finding?
I would suggest that that if you want to provide for that, that we add a new subsection that says in the event that the 4 members cannot agree, that the panel would issue a no finding or something like that. You certainly could do that. So. But just something to consider moving forward. I'll mark this as just a thing to return to discuss. Okay. Rule 17 covers the recommended corrective actions. So after, sorry about that. After finding that a violation occurred, the panel would have to recommend appropriate corrective action, and this rule just sets out what the appropriate corrective actions are. So for representatives, counseling, training, removal from committee or committee leadership, censure, and expulsion from the House. And then the panel would recommend corrective action in accordance with House rules, which really means that depending on what you're recommending, you may make the recommendation to different parties, and this would be done in consultation with the House clerk to ensure that, for example, censure or expulsion would probably be a resolution introduced by the panel on the floor. But removal from a committee or committee leadership might be a letter to the speaker suggesting that as an appropriate penalty.
So would 4 members have to decide agree on the specific corrective action?
This does not provide that you need 4 members to agree on the corrective action. If 4 members have agreed that there's a violation, then I think a majority of the committee or the panel could vote for the appropriate corrective action at that point. So, in the absence of saying that you need 4 members, I think a majority vote is sufficient. With the House clerk, corrective actions include counseling or training, censure, or removal. Corrective action would be recommended to the Rules Committee, and then the Rules Committee would make a determination of whether they believe that action was appropriate and propose a resolution for House consideration. And then if the regulated individual is an employee of the Speaker or House clerk, the recommended corrective action can be counseling or training, reprimand, loss of pay or vacation days, demotion, or termination. And the panel would meet with the Speaker or House clerk as applicable and present its findings and recommendations. And then the Speaker or House clerk would impose the appropriate corrective action in their view. So this really emphasizes that once it comes to penalties, this panel has only advisory capacity. And not the ability to impose penalties on its own. So, questions? Okay. Rule 18 covers when a public statement would be issued, and this is only if it's a publicly noticeable corrective action. So in that instance, the panel chair or the speaker would issue a public statement, including the nature of the complaint, the identity of the regulated individual, and a summary of the basis for the panel's determination and for the corrective action. You'll notice that the complainant is not included in that. So they would not be identified in the public statement. That's not to say they would be protected from publicity, but
Going back to the first sentence in that, it suggests either the panel chair or speaker. My thoughts are it should be the panel chair. And I think in lots of instances, we try and keep the speaker as a neutral party.
Mm-hmm.
And this may give an appearance of not being a neutral party as Speaker of the House. That's just my thought. I just want to put that out there. See if others feel that way. And I don't know how we would differentiate who would be.
I think the reason the speaker was included, and this is not in favor of keeping the speaker, just an explanation of why it was included, is because the speaker is the one with the authority to remove someone from a committee or committee leadership. And so in that case, the questions may come to the speaker.
Yeah. And that can be done separately, but I think in this case, it suggests that she's part of this process here. And I think we need to keep that clearly delineated that she's not. Anyway, just a thought.
But in the above thing, number 3, the speaker shall impose appropriate corrective action if somebody's a employee of the Speaker of the House. So in some cases, she is directly involved.
All right, I don't need to stay on this. Just wanted to raise that so we can move on.
Well, I think it bring up an interesting point, but
I can mark it for discussion and thought. So the instances when a public statement would be made are for a representative removal from a committee or committee leadership, censure or expulsion, for House clerk or an employee, for the House clerk, censure, removal, and for an employee demotion or termination. So it's something that would be visible to the public or plainly visible to the public. So that covers really the notice and the whole hearing process. Rule 19 gets into time periods, and the time period is just as soon as reasonably possible. In the past, we had attempted to come up with more concrete time periods. The challenge being that a reasonable time period is going to depend on the nature of the complaint, the time of year, the availability of witnesses and committee members. And so it was really hard to come up with a concrete timeline. In some cases, it also depends on the availability of the complainant to pursue their complaint and their action. Sometimes there's a need for follow-up and clarification, and the complainant is not available to provide that follow-up and clarification that's necessary to take action. So that's why we ended up at as soon as reasonably possible rather than a more concrete timeline.
and I think in that case, like just communication would be really important. Like we're working, for the complainant, we've heard your complaint. This is why it's taking this time, so that the complainant doesn't feel that their complaint is being dismissed or ignored or not taken seriously.
Yep.
Okay.
Rule 20 covers confidentiality. It requires members of the panel staff, and any other individual that the panel is contracted with to keep confidential any information obtained under the policy, and all panel discussions and deliberations conducted pursuant to the policy, and then all records produced are required in accordance with the policy. This would include any letters, emails, and other communications that are created. And then the only exception is except to the extent necessary to carry out an investigation or as otherwise set forth in the rules. And then all records are not subject to the Public Records Act. One of the things to consider here is whether you want to permit, for example, the claimant to waive confidentiality of certain records in certain instances. So this would be, for example, if you have a complaint where it falls both under the jurisdiction of this panel and the discrimination panel, would it make sense for the claimant to be able to waive confidentiality? Or if the claimant is filing claims against multiple respondents for related actions, and some of them fall under the jurisdiction of, for example, the Senate panel, and this panel, those would be instances where the claimant may want to waive confidentiality on a limited basis to allow the panels to communicate with each other. I think that would be something you may want to consider, but it would have, in that case, it would be driven by the claimant.
Right.
So they can provide a limited waiver in writing to the panel or something along those lines.
Yeah.
Seeing heads nodding, so I'll add that language.
Agreed,
that.
yeah.
Okay, Rule 21 just permits individuals to appeal a final decision of the panel resolving a formal complaint within 15 days after the panel issues its decision. And it would have to set forth, the appeal would have to include a concise statement of the reasons that the individual believes the panel's decision was an error, and may include a request for a hearing on the appeal. Ledge Counsel maintains all records pursuant to Rule 22. And that is it for the rules here,
Who's the appeal
right.
panel? Who makes up the appeal panel?
this panel.
Oh,
So,
So I just want to share a pet peeve, and I'm going to turn to Carolyn, as an educator. And looking at Rule 20, if a student came to you with a sentence that was 8 lines long with very little punctuation, this happens in statutes sometimes. I'm thinking, is this a concise statement? What would you say?
I would give it back to them.
Right.
To say, to make it clearer so people could understand it when reading.
Yes.
duly noted.
Okay, so we better move along here. Can we meet next week?
yes.
Does that give you enough time, Damien?
Today was the last day of my radiation.
Yes.
Congratulations.
Congratulations.
So
All
I
right.
won't be late anymore, or
Yeah.
absent,
Great.
hopefully.
Congratulations, that's
Yeah,
great.
congratulations.
Is that reasonable for you, Damien?
Yeah,
Okay.
it should be. I don't have wood to knock on, so I'm not going to make any statements here. But it looks like I'm available until 9 next week.
Okay.
And I can confirm with Senate Economic Development
Okay,
that start time and see if I can extend it a little bit.
okay.
But we can always get started.
We could get started and go through the suggestions that we made today